How to file for child custody in Oregon. If your child lives in Oregon and you want custody, you will need to file a petition with a court in the state of Oregon. Decide if you will file alone or jointly with your child's other parent. If you and your child's other parent can come to an agreement on both physical and legal custody, your case may proceed much more quickly, as you may not have to have a hearing. There are several types of family law cases in which you can ask the court for a custody order. Method 1: Filing for custody in divorce or separation. 1. Work on a parenting plan. Child custody is a major question in a divorce where the couple has children. If both spouses can agree to a parenting plan, the court will not have to hold a trial or hearing to determine custody. Talk to the other parent about how to divide the child's time at both of your homes. Remember to account for each parent's work schedule and the child's school schedule. For example, if you sometimes work an evening shift and will not be home to care for the child, let the other parent have the child on those days. Decide who will get physical custody. The child lives primarily with the parent who has physical custody. The other parent has visitation rights and can visit the child or have the child visit him or her. Decide who will get legal custody. Legal custody refers to the right to make decisions about the child's health care, education, and religious upbringing. It is possible for one parent to have physical custody, while they both share joint legal custody. 2. Talk to a mediator. If you have any trouble reaching agreement, try talking with a third party who can act as a neutral negotiator to help you make the best decisions. Every county in Oregon has a court-connected mediator program, which can help parents construct a parenting plan. Depending on the county, these services may be offered free of charge. Ask the court clerk how you can schedule mediation with a court-connected mediator. Some counties require that parents of minor children attend mediation during divorce proceedings. 3. Consider any safety concerns. Oregon provides sample parenting plans to use as starting points for creating a parenting plan of your own. Some sample plans are intended for use in situations where there are concerns about the child's safety. Safety-focused plans can specify that one parent can only have supervised visitation with the child, or place limits on overnight visitation. Consider a safety-focused plan if the other parent has ever hurt you, the child, or a pet when angry, threatened or attempted suicide, abused alcohol or drugs, kept your child from you, threatened anyone, sexually abused anyone, or needed medication to be safe around others. 4. Fill out a parenting plan form. You can find blank parenting plan forms at 5. Have your forms reviewed. Before anything is signed, have your forms reviewed by a courthouse facilitator. Most courts in Oregon have a courthouse facilitator program, which helps people with family law cases. Most facilitators offer document review services, either for walk-ins or by appointment. You can find detailed information for facilitator services in each county at 6. File the forms with your local court. Make copies of your forms and take them to the court clerk. The clerk will stamp the original and the copies as filed and retain the original document. The judge will review the agreement and sign the bottom of the form. Once the form is signed by the judge, the agreement becomes a court order, and both parents are required to follow the agreement. Your parenting plan should be part of your dissolution petition. The filing fee for a dissolution of marriage is $273. If you cannot afford to pay the filing fee, ask the court clerk for information about filing an application for a fee waiver. Method 2: Filing for custody when the parents are unmarried. 1. Determine whether you are the legally recognized father of the child. To have full custody and visitation rights, the father of the child must be legally recognized as the child's parent. If a man is married to a child's mother when the child is born, the man is presumed to be the child's father. The other ways to establish paternity are a voluntary acknowledgment of paternity or a court order. Acknowledgement of paternity forms are given to the mother in the hospital at the time the baby is born and must be signed before a hospital witness. To get a court order establishing paternity, contact the Oregon Child Support Services program and ask how you can file an application for support enforcement services. You can contact the Oregon Child Support Services program office by calling one of the phone numbers listed at 2. Complete a petition for custody and parenting time form. This form is available at 3. Fill out a summons, Domestic Relations Unit form. This form is available at 4. Attach a certificate regarding pending child support proceedings and/or existing child support orders judgments form. You can download this form at 5. Fill out a family law confidential information form. You can find this form at 6. Complete a summons, Domestic Relations Suit form. This form is available at 7. Complete a petitioner's certificate of mail to the Division of Child Support form. This form is available at 8. Have your forms reviewed. Before anything is signed, have your forms reviewed by a courthouse facilitator. Most courts in Oregon have a courthouse facilitator program, which helps people with family law cases. Most facilitators offer document review services, either for walk-ins or by appointment. You can find detailed information for facilitator services in each county at 9. File the forms with your local court. Make copies of your forms and take them to the court clerk. The clerk will stamp the original and the copies as filed and retain the original document. Filing your forms initiates a court case. The clerk will contact you to give you a hearing date. The filing fee is $252. If you cannot afford to pay the filing fee, ask the court clerk for information about filing an application for a fee waiver. 10. Serve the other parent. You will need to have copies of your forms delivered by the sheriff, a professional process server, or someone over 18 and not involved in the case. Have that person complete and sign a declaration of service form, which is available at 11. Attend the hearing. At the hearing, the judge will ask you to answer any questions he or she has about the request you have submitted. The other parent will have the opportunity to state why he or she might object to you having custody. Try to anticipate these arguments and figure out in advance how you want to respond. Method 3. Filing for custody in a paternity case. 1. Complete an application for child support services form. This form is available at 2. Attach an affidavit in support of establishing paternity form. This form is available at 3. Have your affidavit notarized. Sign the affidavit in the presence of a notary public. The notary will notarize your paperwork, verifying that you signed the document in his or her presence. Bring a valid form of identification, such as a driver's license or passport, to verify your identity. To find a notary online, visit the Notary Public directory. You can also find a notary public by visiting your local bank. Most banks do not charge a fee for notary services if you are a bank customer. If you are not a bank customer, you can use the bank's notary service for a small fee. 4. Submit your forms. Mail your forms to CSP, 4625th Avenue Northeast, Suite 180, Salem, Oregon 97301. Alternatively, you can take it to your local child support office. You can find the locations and phone numbers of the child support offices in Oregon at 5. Wait for a response. The child support office will process your case for you, and will contact you if they need you to provide additional information. The Department of Child Support or District Attorney's Office will serve you and the other parent with copies of papers after the case has been initiated. Thus, you will be notified when a hearing is scheduled. 6. Attend the hearing. At the hearing, the judge will ask you to answer any questions he or she has about the request you have submitted. The other parent will have the opportunity to present evidence to try to prove that you are not the child's father. Once your paternity is established, you can request custody and a parenting plan. Method 4. Filing for temporary child custody in an emergency. 1. Fill out an ex parte motion for temporary custody and parenting time form. This form is available at 2. Complete an affidavit in support of ex parte motion for temporary custody and parenting time form. This form is available at 3. Include an ex parte order for temporary custody and parenting time form. This form is available at 4. Have your forms reviewed. Before anything is signed, have your forms reviewed by a courthouse facilitator. Most courts in Oregon have a courthouse facilitator program, which helps people with family law cases. Most facilitators offer document review services, either for walk-ins or by appointment. You can find detailed information for facilitator services in each county at 5. File the forms with your local court. Make copies of your forms and take them to the court clerk. The clerk will stamp the original and the copies as filed and retain the original document. Filing your forms initiates a court case. The clerk will contact you to give you a hearing date. There is no filing fee. 6. Attend the hearing. When you return to court for the hearing, the judge will ask you questions about your petition before he or she grants your request. The child's other parent will have the opportunity to deny any allegations of abuse or neglect. Bring any evidence and witnesses you can use to demonstrate that it would be in the child's best interests to be removed from the parent and placed in your care. 7. Serve the other parent. Have the affidavit, motion, and signed order from the judge served on the other parent. You cannot serve the other parent yourself, but you can have the sheriff's office, a professional process server, or someone who is over 18 and not part of the case serve him or her for you. If you cannot locate the other parent to serve him or her, check with friends, family, employers, former landlords, the tax collector's records, the DMV, and the post office. You can even hire a private investigator. If all else fails, ask the court clerk how to request permission from the court to give constructive notice by publishing notice of the case in the newspaper. 8. File an affidavit of service form. Have the person who served the other parent complete an affidavit of service, which is available at http://courts.oregon.gov OJD Docs OSCA CPSD Court Improvement Family Law Affidavit Serv 16/02_000.pdf. By signing this form, he or she verifies that the other parent was served. Then you must file the affidavit with the court clerk. If you already have a custody judgment resulting from a divorce, separation, or custody case, fill out this form instead. http://courts.oregon.gov OJD Docs OSCA CPSD Court Improvement Family Law Affidavit Serv 16/02_000.pdf. Warnings. The forms referenced in this article are provided by the Oregon court system, but may not be accepted in every county in Oregon. This article is intended as legal information and does not provide legal advice. If you need legal advice, contact a licensed attorney.